115-249 in the matter of John M. Knox.
May it please the court, Stan Hazlitt appearing for the Disciplinary Administrator's Office. I would like to reserve 2 minutes for rebuttal.
2 minutes is granted.
We're here as a result of a hearing that occurred on October 8th of 2015. The respondent appeared at that hearing, but was not represented by counsel. There were multiple rule violations found arising out of the respondent's representation of the complainant in this case in a number of different legal matters, but all kind of tied into each other. A divorce action, a PFA action which she had filed against her spouse, a misdemeanor criminal battery which had been filed against her, a child in need of care case which had been filed against both parents involving their 2 children. The panel found that there were violations of diligence, communication, fees, safekeeping of property, termination of representation, KRPC 8.1 and Supreme Court Rule 207 because of the failure to cooperate during the investigation. The respondent has taken no exceptions to the findings of fact and conclusions of law made by the panel. Our recommendation at the hearing was a 1-year suspension with the 219 hearing. The panel recommended to this court a 6-month suspension with the 219 hearing, a reinstatement hearing. The respondent requested that he be placed on probation. The panel rejected making that recommendation to this court, finding that his plan was not a workable, detailed, or substantial plan, and also that they found that the respondent engaged in dishonest conduct, which could not be remedied by probation. Specifically, the panel found that on 3 separate occasions during the respondent's testimony, he engaged in dishonest conduct when he claimed a date that he withdrew from the complainant's cases versus what the complainant said. They adopted what the complainant said and said that her testimony was more credible. His testimony that his laptop had been stolen, which was the reason that he didn't communicate with the complainant. And finally, his testimony that the complainant had told him not to communicate with opposing counsel, which is why he said that some things didn't get done, because he had told that he should not communicate with opposing counsel. The complainant testified just to the opposite, and the panel found that her testimony was more credible. All of this, I would argue, and the panel found, would disqualify the respondent from being placed on probation. I believe the 1-year recommendation with the 219 hearing is appropriate. If you look at the record, it shows that the complainant's problems were manageable and that she was eager to get them resolved. She is a pharmacist. She was anxious to get all of these matters resolved. It was obviously terribly trying on her to have all of these hanging over her head. The problems were not addressed properly, the record shows. They were not addressed diligently. The respondent made the decision for some baffling reason not to communicate with opposing counsel, which caused huge problems. I mean, if you read the record, opposing counsel testified. He was anxious to get these things, get the divorce taken care of, to get the child in need of care cases resolved, to put up a common front in the child in need of care case. But that just didn't happen. For some reason, the respondent did not properly handle these cases. The findings of the false testimony, obviously, is very troubling. Finally, there was injury to the complainant. If you read the panel report, they note that the respondent lost her job as a pharmacist during this process, that there was just a lot of turmoil surrounding her, that there were phone calls, personal phone calls that were being made to her place of business. And finally, she was terminated as a result of that. The respondent, in addition to that, the divorce was never concluded. There was an instance in this case where the respondent charged a non-refundable retainer. He charged $6,000, I think on February 11th of 2014, used the words non-refundable. Within 8 days, the complainant wanted to terminate his services. There's an email, I believe, in the record well, I know it's in the record, I'm just not sure if it's an email or a letter, which said, I'm not giving you your money back. I'm just not going to do that. This is non-refundable. I earned it when I got it, didn't go into his trust account. So she felt compelled, or felt like she had no choice because she had no other money to stay with the respondent.
Has that money been returned? Is the $3,000 that's been ordered in restitution, do you know if that's been paid?
Actually, it's been paid by the Client Protection Fund.
Okay.
But there's been no compensation back to the fund.
Let me ask you about your recommendation versus the panel, because the panel had a notation about a condition of precedent for the reinstatement was a payment of $3,000. I don't see that as a part of your recommendation.
That's true. I didn't specifically make that recommendation, but I think it almost goes without saying that the fund would have to be reimbursed as a condition of reinstatement.
There was also, and I don't mean to interrupt your presentation here, but maybe you were getting to this. There were previously 3 occasions in which the respondent has been admonished. Were they, and you don't need to go into the details of those, but were they similar kind of conduct or what?
One was not. One was an advertising issue.
Right.
The
Right.
two others, I believe, had to do with diligence and communication, so somewhat similar. I want to make sure that
I think that's right. So yeah, I remember that. Okay.
that's correct. I mean, all of these factors led to my recommendation of a 1-year suspension with a reinstatement hearing. And I would say that a reinstatement hearing is, in my view, an absolute necessity. As I read through the transcript, the respondent testified that just prior, and I'm not sure, I think maybe 10 days to 2 weeks prior to the actual disciplinary hearing in this case, that he had was in the hospital for 8 days as a result of an episode of major depression. So although there was no professional testimony presented at the hearing, so that the panel could conclude that that was a mitigating factor, because that would be a requirement, there was the respondent's testimony, which I have no reason to disbelieve, that he was, and I guess he will maybe address that today when he addresses the court, whether there still is, but there certainly was right prior to the time of the hearing, which could explain some of the misconduct. But certainly with respect to looking at a 219 hearing, I think it would be an absolute necessity to make sure that he's addressed those issues before he's allowed to practice law again. I'd be happy to answer any questions.
Any questions? Thank you, counsel.
Thank you.
May it please the court, I'm John Knox. I'm appearing pro se. I have a couple things that I'd like to address. But first, I would like to thank the Kansas Lawyers Assistance Program and Ann McDonald and Bryn Rose and Ray Sedgwick, who is a counselor for me, and Christy Edwards, and also Paul Seymour, the attorney who supervised me while I was being helped by KLAP. They were all very helpful to me. I would like to address a couple of things, and I have already admitted fault for those things that I was found at fault for, with the exception of the lack of credibility, but I want to address that. I didn't appeal it because I don't think that who the panel found was more credible between two witnesses is something very appealable, because you had to be there to judge credibility, and the panel was, and you all weren't. but I want to tell you that all my life I've been under vows or oaths of office. From the time I was 8 days old and baptized in the Roman Catholic Church. I mean, there's even a scout oath, confirmation. 35 years ago, next month, I will have been ordained a priest in the Episcopal Church for 35 years. I was an Army officer under an oath, including to the Constitution of the United States, like the attorney's oath is, for 4 years. And I've always taken those oaths very, very seriously. And while the complainant and I have 180-degree different perspectives on almost everything that happened, there certainly was no other evidence other than the judgment of credibility that I was lying about anything, and I didn't lie under oath. I wouldn't, and I didn't. My laptop was stolen. She did tell me to cease communications with opposing counsel. It was a mess, and you know, is my mistake not refunding her money and getting out of that case immediately. It was the biggest mess of a case I've ever been involved in my life. And I had a client who was deliberately working against me and her own interests throughout until representation ended. I didn't lie to her or to the panel about the termination of representation. I told the panel exactly what my understanding was about the way it happened. In the middle of this case, on March 31st of 2014, I had total right hip replacement surgery. So I was in the hospital for 4 days, and then I was homebound for 2 weeks and couldn't drive for 6 weeks, which was a huge setback in the midst of all of this. I did arrange for coverage for her court hearings in Leavenworth County, and while I'm completely willing to admit things that I did do wrong, and tell you, as I told her, that I am sorry for those things, hence no appeal of the panel decision. I don't want to be held accountable for things that I did not do wrong. Now, I see there's a problem in that the panel found that my proposed plan of probation was not specific enough. I got model proposed plans of 3 of them from KLAP, which I used. All of them, it was my understanding, had been approved by the panel in the past. So that was my model, which I followed. It was developed with Paul Seymour, who thought it was adequate, and it was ongoing. So I was doing the things that were in the plan. I don't know how to make it any more specific than I did, and I can't find any specific guidance about how specific it has to be. So those are the 2 things about the panel's decision that I contest. First, that I didn't lie, and second, that there is a procedural disconnect in developing probation plans, and a lack of specific guidance on what they're supposed to include. Because I'd gone over it with Bryn Rose and Paul Seymour. It seemed good to them. It had me doing a lot of things which I did. So I was a little bit disheartened that the plan was not approved for that reason. I'd like to talk about depression because I was diagnosed with major depression and anxiety disorder. I've been treated for it ever since then with counseling, and I see a psychiatrist who I think is really good. I'm taking psychotropic medicines for that.
Counselor?
Yep.
When was that diagnosis? Before or after this?
The diagnosis was before the panel. That diagnosis was before the panel hearing, but I've been diagnosed with major depression and PTSD for probably 7 or 8 years before that by a psychiatrist in Lawrence named Mary Frank. At the time of, in fact, on the day after my hip surgery, my paralegal of 10 years, who was Roberta Hofer, was very excellent paralegal, retired. And so I was basically left without office staff at that point. My depression was very severe. It certainly improved a lot with medication, but it's something that I probably will have to continue to struggle with. And I was depressed to the point of having suicidal ideations. I am not alone in this. There is a crisis in the bar that approximately 30% of attorneys suffer from diagnosable major depression. There are probably many more have situational depression, but 30% with major depression, and approximately, although the data are difficult to gauge as far as accuracy because statistics aren't kept very well with regard to mortality of suicide and profession, but approximately a lawyer a day commits suicide in the United States. So I think that's a crisis. I've been practicing law 22 years, and I think even in my experience and having heard from older and more experienced, many more years experienced attorneys, the practice of law has hugely changed. It's changed a lot in 22 years. There was a lot more collegiality, in my opinion, when I started practicing law, mutual support, and there wasn't, at least in my own experience, the kind of viciousness that I found toward the end of my career.
What is your current practice? What are you doing now?
Right now, I'm not practicing. I'm winding up. And in fact, one of the things I need to tell the court is what I would like to do is retire and just surrender my license.
Say that again.
I'd like to retire. I'd like to just surrender my license.
As of when?
Do you have any remaining files?
I have files that I need to get to clients, so it would take me 2 weeks to a month probably to complete that process.
But at the end of that time, it's your desire to submit surrendering of your license?
That's
Is
what
that
I'd
correct?
like to do. Right.
Are you aware that by rule, that means that disbarment is automatic?
Right, I understand that. although I've got to say that I was heartened by the cogent arguments that I heard this morning. I was a little bit juiced by that, and it made me think maybe I ought to still practice. But I have a 32-year-old son with cerebral palsy and severe autism and a number of psychiatric disorders. My wife isn't well, and they need my attention. And I think
Counselor, given all that, surrendering your license and being disbarred by rule is very different from accepting a suspension, retiring, not seeking a reinstatement hearing. I mean, have you considered that difference? I think that's what Justice Johnson was driving at.
I hadn't considered that, but
As a practical matter, you would end up in the same place without having disbarment, is what we're getting at.
right. I would leave open the option of seeking reinstatement if I ever wanted to change my mind, I suppose.
That leaves us to the question, what are you asking us to do about this case?
I'm not contesting the panel's recommendation about the 6-month suspension. Of course, given the circumstances, I'd rather have a 6-month suspension than a year suspension, but in a way, since I don't intend to return to practice, it doesn't matter that much to me one way or the other. I just don't have the emotional energy to continue practice right now. You know, if in 6 months or a year I felt well enough to come back to practice, I could apply for a reinstatement hearing and my psychiatrist testify that I'm well enough. But I don't honestly anticipate that happening.
But as was suggested earlier, that is an avenue that would be available to you, and you would not necessarily want to burn that bridge.
I think that's a good suggestion, actually.
All right.
Thank you.
Any further presentation for us today, Council?
No, thank you. That subject any questions concludes what I have to say. Thank you.
Do we have any more questions? Thank you. You reserve 2 minutes.
Just a few observations. Again, I want to emphasize the respondent did not take exceptions. So to stand up here and quibble with the findings of fact made by the panel is not permissible under the rules. He indicated to you that his laptop was stolen, contrary to what the panel found, did not believing his testimony. That was really based, if you read the record, on the fact that he had never brought that up before at any point. He finally cooperated with the investigation. He did not bring that up with respect to the issue of communication with the investigator, and it was not brought up in his answer. Stating that the complainant was deliberately working against her interests, which impeded his representation of her, I don't think there's any evidence in the record. To the contrary, the evidence in the record was that she was trying very hard to resolve these issues, but couldn't get in touch with him, and that was a huge problem. The hip surgery, which he described as a huge setback, it was the day before the child in need of care case that he found somebody to represent her at what he described as a status conference. It wasn't a status conference, it was the real deal. It was a determination as to what was going to happen in that case. Lack of guidance about probation plans, he's disheartened about that. I mean, if you were to read the cases by this court where lawyers are placed on probation, probation terms are set out in the opinion, you very easily craft a plan. There's plenty of guidance out there. You know, on the depression issue, that is something that if you were going to allow the respondent to practice, there absolutely had to be testimony from a professional at that hearing to explain that depression really existed, that there was a correlation between the misconduct and the depression, that there was a period of rehabilitation, and finally, in the opinion of the professional testimony, that the misconduct was not likely to reoccur. None of that was presented by the respondent. So for those reasons, I would again ask the court to adopt the one-year suspension that we're recommending.
As a practical matter, is there a huge difference? If we say 6 months, he has to make application, pay a fee for reinstatement. You go through the whole process. A 6-month suspension with reinstatement means 1.5 years, 2 years, doesn't it?
Well, I hope it doesn't take that long, but
It seems like it does sometimes.
well,
But
that may be true.
Anyway, there's at least a significant amount of time required for the reinstatement process.
That's correct.
Yep.
And I think under the facts of these cases, the period of suspension should be significantly longer than the 6 month.
Any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement. That